Let's get some more on today's hearing and the issue of regulating political ads on the internet with Randal Milch. He's a distinguished fellow at the Center on Law and Security at New York University School of Law. Randal, thanks very much for joining us. Listening to that testimony today, we heard some staggering numbers that Roe alluded to there. 26 million people who had on Facebook who directly had news feeds that had material that was paid for effectively by the Russians. 126 million people who may have been served by the Russia-based IRA. One other figure that interested me as well was that Facebook's advertising revenue in the last quarter grew by 47%, which is huge. And the fact is, these companies need these adverts to survive. So the truth is, any kind of compromise, any kind of laws that would penalize them for their advertising, that's not going to go down well, is it?
Well, Owen, thank you for having me on. I think that the Facebook ad growth, the revenue ad growth that you cited is very significant, as you say. But the question is not whether these ads will continue, right? The question is under what set of regulations might they continue. I don't think that the total ad volume for these political ads is significant in comparison to the ad volume overall. Right,
$100,000 or so is probably not that big in the grand scheme of things. What you're saying effectively is, though, fake news, these kind of fake adverts that Russia's accused of planting, they're here to stay on social networks.
Well, I think that there are steps that can be taken. The Honest Ad Act, which is, I think, the law that was referred to prior to in the piece, will take some steps to spread the existing regime that requires some disclosure of who purchase ads to the internet medium. I think that the internet companies themselves have a strong interest in self-regulation here because of a unique position that they have in the law. For over 2 decades, social media has had a privileged place in American law because they have been immunized from many sorts of lawsuits. This so-called Section 230 immunity is something that Congress granted them. And what Congress giveth, Congress can take away. So I think that they are very keen on protecting their immunities, which are very valuable to them. And so self-regulation and agreeing to some additional regulation on the political ad side only makes business sense for them.
But that rarely works, doesn't it? Let's be honest. Self-regulation in most industries, really, it's only the threat of serious financial penalties that would make these companies sit up and take notice. If they know they're going to lose advertising revenue, that shareholders will be upset, that would make them sit up and take notice, wouldn't it?
Well, I think that would make them sit up and take notice, but I think you're underestimating the importance of self-regulation in this area. As I said, Congress can always take away their Section 230 immunity. That would have a very devastating effect. So I think that they have a strong impetus to do it. I think that it's going to be visible. There's going to be some effort to, after every election, have this sort of autopsy to see what happened. So I don't think that it's going to pass unnoticed. I think that that they do have the means, certainly on a technological level, and I hope that between these hearings, potential additional laws that are passed, a new effort by the Federal Election Commission, that they will sit up and take notice of those items.
Randal, a couple of lawmakers I heard were making the point about threats to the First Amendment, to free speech, which is obviously sacrosanct here in the United States, and that by policing sites like Facebook and Twitter more stringently, there could potentially be compromises to free speech. What do you make of that argument?
Well, we do have a very strong and long tradition of protecting free speech in the United States under the First Amendment. The law, however, has taken note that in political ad area, disclosure is not a threat from a First Amendment position. So I think that you have to distinguish between political ads and other types of speech on the internet. Yes, there are certainly significant issues with organic posts, and there may be some very significant First Amendment blocks to any attempt to regulate those. But requiring a certain amount of disclosure around political ads, I don't think is a significant First Amendment problem. You have to know exactly what the law says before you can make that judgment. But as a theoretical matter, there's certainly room there consistent with the First Amendment.
Randal, we'll have to leave it there. It's a fascinating discussion and one that I know is going to go on and on. Thank you very much for talking to us, Randal Milch.